Hello everyone, so welcome to the tutorial for the area of criminal law that is non-fatal offences. Non-fatal offences refers to a group of offences where a defendant could be charged and convicted of causing injury or harm to a victim or victims. These offences operate on a level of hierarchy, so the higher level harm or injury that is caused, the greater the offence will be, and you will be able to have a look at practical examples of this through your charging standards in your non-fatal offences booklet. So there is a copy of those for you. The police and the Crown Prosecution Service had gotten together to put together a list of potential injuries and harm caused and what they would be charged with accordingly. So what we will look at on this tutorial is the legal area of non-fatal offences, as in what would need to be proven to satisfy each of these offences. That would come under assessment objective 1 for your knowledge and understanding of the law. And then we will look at the application of those areas of law to scenarios, and that comes under assessment objective 2 for application. In future sessions we will evaluate this area, and we will also look at specific defences. Now, the defence of consent is a really common defence that can be used to counter liability for non-fatal offences. It featured on the 2019 exam paper as an essay, but it can crop up in a scenario, so a defendant could raise that a victim consented to harm. Other defences that could apply are self-defence, or defending another, defending property, or acting in the prevention of crime. But these are general defences in that they are available to other crimes as well, such as murder and manslaughter. So the offences we are going to look at are assault and battery. Now, assault and battery are the two lowest level offences. These derive from common law, so if you remember, these are made by judges, but they are also charged. So if a police officer has arrested a suspect and believes they have enough evidence to charge somebody to take them to court for the offence, they will charge the defendant with one or both of these offences under Section 39 of the Criminal Justice Act 1988. So I stress this is the section that you are charged under, but it does not provide the definition or the elements. These are still found within judge-made law. If you are going to be charged and convicted of a slightly higher level offence here, then that would be actual bodily harm. So that could be committing an assault or battery at the lower level stage, which occasions actual bodily harm, and we'll look at that in more detail. But what you'll notice here is that then switches to a different piece of legislation, the Offences Against the Persons Act 1861. So these are all really old offences, and they have been around for hundreds of years. They have been developed mainly through judge-made law, as we will see, but we do have this piece of legislation which is obviously very old, roughly 150 years old, so it does need reforming. The most serious level of non-fatal offences are those charged as a grievous bodily harm or a wounding, and we have two different sections under the Offences Against the Persons Act for those offences, and we will look at the difference between those, but ultimately you will not be charged and convicted of that level offence unless you are believed to have caused the greater level harm that is known as grievous. So just note the spelling of grievous as well. So we're going to look at the lowest level charges of assault and battery first of all. So these are two low-level crimes. Can be quite difficult to prove because you could be looking at, if you review the charging standards, really low level or even no injury And the terms are quite misleading, because what you'll see here is that an assault is actually defined as something which causes a victim to fear. So the wording is an act which intentionally or recklessly causes the victim to fear immediate unlawful force. So the crime you're committing is actually doing something that causes somebody else to fear, and this doesn't need to be physical, which contradicts how we use the term assault in modern day life. So assault does not necessarily refer to a physical action, but the physical action can be charged as a battery. If you see here, it's the application of unlawful force. So what we have are two offences that could be charged separately. You could think about where somebody might fear, but there would be no force used against them. And equally, on the other hand, where force might be used against somebody, but they haven't feared. So the two could be charged separately, but also, more commonly, they are charged together. And together, the charge is known as common assault. So if you ever see that or read about that, that is an assault and a battery together. And these are charged under the Section 39 Criminal Justice Act. These are summary only offences, so regardless of whether you're charged with one separately or both together, the maximum punishment you can receive is 6 months imprisonment or a fine of £5,000 as an individual. Now, I said in the previous slide that these derive from common law, so they've been judge-made law offences, and actually they were not first used in the 60s, but the court, the Queen's Bench Division in Fagan against Metropolitan Police Commissioner, if you remember this case, being the defendant drove onto the policeman's foot and refused to move, then was charged with a battery committed through the application of force via his car. Obviously, the argument there that we've looked at before was whether the actus reus and mens rea of that offence coincided. But the Queen's Bench Division also took the opportunity to define the difference between assault and battery. And there are a number of other cases that have attempted to define these as well. So you may refer to in your reading a case of Venner. You would also come across a case of Ireland as well. So there are a number of cases where judges have tried to define these offences. You only need to use one. So we'll start with assault then and pick apart the elements, because remember, as trainee lawyers, what we need to do in a scenario is identify the offence that has been committed and then pick apart the elements to reach a conclusion as to whether somebody is guilty of that offence or not. So what could constitute an assault? So as I said before, it's not really going to be anything necessarily physical, because a physical act would be charged as a battery with the application. So what could cause somebody to fear could be words, and these words could be either written or verbal. So there are a couple of cases here where the courts were able to find the defendant guilty through using words to cause a victim to fear. So we have the case of Constanza, where Constanza wrote letters to their victim, and some of which the victim felt were threatening. So this is an illustration of written. We had a case of Wilson, where Wilson shouted, "Get out the knives." That was deemed to be a verbal threat. And we had a case of Ireland. Please do look at Ireland online, because it's a really famous case in this area, really well-known reported case for assault and battery. And this is where Ireland made a number of silent telephone calls to the victim. It was quite groundbreaking, really, because how do you prove that type of conduct? that is causing the victim to fear, particularly where a defendant isn't saying anything. So it really widened the remit of what could be constituted as an assault. What could we evidence in terms of something causing apprehension or fear? And of course, that needing to be immediate. That's what the crime is about. It's about an act which is causing the victim to fear immediate unlawful force. So, of course, the victim must fear that force is going to be used against them. And a court has said, in the case of Smith, imminently. So what do we mean by immediate? We mean, or we take that to mean imminent, which is almost instantly, in the very near future. So this is quite a famous case here, the case of Smith against Chief Superintendent of Woking Police Station. Now, you might remember me saying that prior to the Crown Prosecution Service being set up and taking on prosecutions from 1986, police officers and senior police officers used to actually prosecute cases instead. And that's what we have here in the reference. Older criminal cases, you will see that police officers have prosecuted them, and they are included in the citation. What we of course have now that the CPS is formed is we'll have R for Regina, or we'll have DPP for the Director of Public Prosecutions, or maybe even AG for the Attorney General. So here this was an appeal case, so obviously then the defendant is appealing against the police, appealing against their conviction, but the police officer who led this prosecution was the Chief Superintendent at Woking Police Station, and that's why the citation is as it is. So this case is interesting because this is where Smith broke into a garden, and the victim, a young female, saw him looking at her through her ground floor window. Now, there was no evidence that he was actually going to be able to break in, or that he was going to break in and cause her any harm after that. But he was convicted, and his conviction was upheld on the basis that she didn't know what was going to happen next, so the fear was actually imminent. You hopefully remember this case from Involuntary Manslaughter, and this was a case involving an issue of whether fear was caused to the victim or not. Now, we know that the victim in Lamb did die because Lamb shot his friend, thinking that the gun in the particular chamber, there weren't bullets, so the gun was unloaded. But remember here, Lamb was found not guilty because his friend was not believed to have feared. So where Lamb was charged with committing an unlawful act that was dangerous and caused death, the unlawful act was charged as an assault on the basis that pointing the gun at his friend was to cause fear. And this was deemed not to be the case, so therefore he was not guilty in the end. Interestingly, we might have words used to cause fear, but equally a defendant can take away that fear with use of words as well, particularly if what they're threatening is not going to be immediate. And this is a really, really old case, Tuberville and Savage, where a defendant did use threatening language, but the words they used indicated that any threats were not going to be carried out immediately. So what they did was remove the fear. And this, being a very old case, was at a time where courts were more mobile. So you would have what they used to call the court of assizes that would travel round, and they would try and convict people in public, in a market square, through this mobile set-up court. Obviously 1600s, very different. So these two parties, defendant and victim, were having an argument, and the defendant said, if it were not assize time, which meant if the court wasn't here, then I would not take such language from you. So they were basically saying, if the court wasn't here, I would be decking you. But given that the court was there, that fear could not be immediate. So therefore, they couldn't be guilty of the offence of assault. So just make sure that you identify whether that threat or fear is of immediate force or whether it is for some time later. So it can't be, I'm going to beat you up next week or I'm going to beat you up tomorrow. It has to be something more immediate for a defendant to be guilty. The mens rea is that the defendant must have either intended to cause the victim to fear or have been reckless as to whether the victim fears or not. So we go back to our original principles and apply those. We decide, did the defendant intend to cause the victim to fear, or through their conduct were they reckless? So did they see a risk through their actions, which is more of an indirect way. So these are the tests that we apply. Remember, for all crimes other than murder, we only apply the direct intention test. So was the act the defendant's main aim or purpose from Mohun? If we believe that the defendant's conduct indicates more reckless conduct, then we apply the test from Cunningham. Did the defendant realise the risk of harm and carry on or continue anyway? Just a point to note here, I often see students forgetting to apply the mens rea, so make sure once you've identified the elements of the actus reus, you then apply the mens rea. And a really good thing to do would be to summarise this area and set out the elements separately. So we need to identify the act, we need to identify that the act has caused the victim to fear. That fear needs to have been of immediate unlawful force, and we need to have the mens rea. So we've got the act, the fear, the immediacy, and the mens rea. So we've essentially got 4 elements there that you need to state and apply. The best way to summarise would be to separate those out and make sure you have the illustration cases for those. So for a battery, this is, of course, the more physical element of common assault here. So this involves the application of unlawful force. So obviously force needs to have been unlawful. It could be deemed lawful if a defendant is believed to have used a relevant defence. So it's the same as with the crime of murder. For example, with the offence of murder, remember we were discussing as to whether the killing is lawful. Could a defendant potentially raise self-defence or defending another or property or acting in the prevention of crime? Similarly, principles apply here in terms of where you're applying force to somebody or you're causing a victim to fear unlawful force. If there is anything that indicates that that force used or threatened could potentially be lawful, then that could give the defendant a potential defence. So if self-defence, defending another, defending property or acting in the prevention of crime are a feature in a scenario, you may deem the force used to be lawful. But remember, that force needs to have been used reasonably. So any excessiveness, such as in the case of Martin or Clegg, that type of excessiveness, overuse of proportionate force, that will not make the force lawful. Now, the application can be committed by a positive act or by actually failing to act. And there's a famous case of Santa Bermudez where a defendant was being arrested by a police officer, and the police officer asked him whether he had anything in his pockets that could cause her harm. And the defendant said no, he didn't, but actually he had a needle. And when the police officer searched his pockets, she cut herself on the needle. Now, luckily, the needle wasn't infected, otherwise we might be looking at a greater offence here. But in the end, the defendant was charged and convicted of a battery causing actual bodily harm because of the nature of the injuries. Now, that was deemed to have been an omission, given that the defendant actually created a dangerous situation by failing to tell the police officer that he had a needle in his pocket. Now, the force can be applied directly or indirectly, and directly would obviously be the more common way, so it would be like a shove, a push, a slap, a punch, a kick, and that would be evidence of direct. Indirect could be where you're applying force through using an implement or a vehicle. So Fagan is a really good example of using a vehicle to apply force, where the defendant drove on to the police officer victim's foot. But also have a look at this case I've put here, Director of Public Prosecutions against K. This is an awful case, really, where a defendant put some acid into a hand dryer at a school. And that acid, when a student came to use the hand dryer, caused that student burns. So that was deemed to be indirect application of force through, obviously, the implement being the hand dryer. So really interesting case. You could also look at a case called Haystead, DPP v Haystead, and that's Haystead. And this involved an incident where somebody pushed a victim who was holding a baby, and the baby ended up falling on the floor and hitting their head. Now, that might sound familiar to you. We had a scenario based on that for involuntary manslaughter, but that was deemed to be indirect force being applied, obviously causing the victim, the baby, injuries there. The baby didn't die in that particular case, so that was a non-fatal offence. But obviously what examiners have used in the manslaughter scenario we've looked at is they've used those facts and taken it one step further to create liability for a fatal offence. So do have a look at that case as well. All illustrations of how force could be indirect there. And when we talk about force, we might think that we're talking about something particularly serious, but actually, remember, battery is a low level, the lowest level non-fatal offence. So we could, even as we see here with Collins and Wilcock, be looking at a scratch. It could be even more minor than this. It could be reddening of the skin. If you shove somebody, there might be no marks at all. There might be no physical injury, which can, of course, make this really difficult to evidence. So just bear in mind that the force can be slight. It doesn't have to be any greater injury or any injury evidenced here. So you see, I've covered quite a lot on this slide. We identify how the force has been applied. Is it direct or is it indirect? We identify whether the force is lawful or unlawful, and we identify what the force is. Obviously, it's quite wide-ranging. It can be slight. The mens rea is obviously very similar, because this is a low-level crime. We would have intention to apply unlawful force or recklessness as to whether force is applied. There is quite a well-known case that kind of builds on this a little bit more. More often than not, we have defendants who have committed an assault or battery whilst being intoxicated, and what they then might seek to argue is that they didn't form the mens rea because they were drunk. We've got a famous case here, obviously a leading case, given that it was led by a Director of Public Prosecutions, case of Majewski, or I'm told is pronounced Majewski, where a defendant had committed an assault and battery together, and actually the charge ended up being ABH because of the injuries, so it was more of the mid-range non-fatal offence here. And because he was drunk, he was actually held to be reckless. So what this tells us is that if you are drunk voluntarily, your conduct is deemed to be reckless by law. So just keep an eye out for that, where defendants were drunk at the time. That doesn't mean that they have a defence to the crime that they have committed. They may not be able to form the intention unless they've drank to get the Dutch courage to commit a crime. That could indicate intention, but they'll certainly be deemed to have been reckless. But of course, that's if voluntary. If the drink was spiked, the defendant becomes drunk or intoxicated on drugs against their will, then that could end up being a defence that we will look at later in the course. Okay, so that's the law of assault and battery. So remember to split up those elements for each of the offences. And in terms of the type of injuries, these are on the charging standards. We're looking at very low level or in fact minor injuries really. So there doesn't need to be an injury. We're looking at minor bruising, grazing, small cuts. Okay, so application wise, I've put a scenario here. You'll have it in your booklets, and I really want you to have a look and see if you can identify what the offences are here. So we have Sandra being in a park. She spots her ex-boyfriend's new girlfriend Tara. Sandra shouts at Tara and says, "If it wasn't so hot, I'd come over there and smash your head in." Tara smiles sarcastically and Sandra walks off. Annoyed, Sandra runs up behind Tara and grabs her hair. Sandra shouts at Tara and says, "You cow," and tries to punch her. Tara moves and the punch misses her. Sandra produces a knife which frightens Tara. Tara jumps back, hitting her head off a wall and causing severe bruising. Now, a few things to note here really. So we've got a couple of incidents. We've got the first incident of Sandra shouting, saying, "If it wasn't so hot, I'd come over there and smash your head in." And Tara smiles sarcastically at her and walks off. Now, this part here indicates an assault because it's a verbal shouting. So an act causing the victim to fear immediate unlawful force. And a couple of issues spring to mind here. So the act appears to be the verbal words, which we know can be evident. And then, of course, we have the issue of fear. Does Tara fear? Is there something in the scenario that indicates that she may not fear? And then we need to consider whether this is an act that is causing Tara to potentially fear immediate unlawful force. Is this immediate, or is there something said that could negate that immediacy? And then, of course, is the mens rea there? So there may be two particular elements of the actus reus there that I would say are not made out. So potentially making Sandra not liable for that part. And then, of course, we have the second part, Sandra running up behind Tara and grabbing her hair. And then shouting at her, saying, "You cow," and trying to punch her. So we've got running up behind her, grabbing her hair. Of course, at that point, we could have just a battery, because there would be no fear if she's running up behind Tara, unless Tara knows that she's running up behind her. It doesn't indicate that here. and then we have a trying to punch her, which could be potentially an assault. So we've got a couple of things going on here. And then the producing a knife, frightening her, falling back, hitting her head off a wall and causing severe bruising. Is this an assault or battery? So I really want you to think about these 3 incidents in this scenario. This is from an old OCR past paper, and identify whether crimes have been committed here. So I've put a bit of guidance together for you. So the first part, I've put a little bit. So Sandra potentially commits assault, charged under Section 39 of the Criminal Justice Act 1988. She commits an act. Here she uses verbal words to threaten Tara. We can use the case of Wilson to evidence, which she clearly intends for Tara to fear. So she does intend that, doesn't she? There's obviously a bit of background history between them, so we can use Moen to evidence the intention. The assault may not be considered immediate, as her words negate the immediacy. If it wasn't so hot, so that's kind of similar to the Tuberville and Savage type situation. And what you could also add here is the other issue that I think would be evident here in terms of, is this an act which causes Tara to fear? So I just want you to think about what that act might be and what we could add in there. So I've concluded that Sandra is probably not going to be liable. Okay, so that concludes part 1 of non-fatal offences. I think we've covered enough in this session. I would like you to practice the other parts of that scenario as well, so that I can make sure you identify this area of law correctly. And well done.